Welcome to the Littleton Chambers podcast.
Good morning. Thank you very much for joining us for Littleton's commercial group webinar on share sale disputes. It's lovely to see some of you I know and some new names in the participant list. Thank you very much all for coming. I'm David Lascelles. I'm head of Littleton's company law team, and I'm joined by my excellent colleagues today, Lydia Banerjee and Alexander Halban. Each of us is going to talk about a hot topic in the share sale field today for around 15 minutes. As part of that, we're going to discuss some recent cases, and we will provide a full case name and link to the cases after the call in a Littleton LinkedIn post. And we've also got a chat function. So if there's any questions, any points you'd like to raise during the talks, please feel free to pop down them in the chat function, and we will do our best to try and answer them. Probably we'll do that after we've had the talks. So in terms of topics for today, Lydia is going to talk about expert determinations, which are obviously key when you're looking at things like deferred consideration, earn-out clauses, where very typically you will have an accountant or a lawyer carrying out an expert determination in relation to matters in dispute. And Lydia is going to talk about those type of clauses and recent cases dealing with attacking those clauses. Alexander's then going to stay on the topic of experts, but he's going to deal with a different aspect. He's dealing with expert evidence during litigation itself. So looking at the pitfalls and practical tips for how to deal with your experts and how not to deal with experts when it comes to giving typically valuation evidence in share sale disputes. First of all, though, I'm going to talk about fraud, and in particular, I'm going to talk about why it is that you would bring a fraud claim in a share sale dispute, and look at a couple of recent cases which tell us about the circumstances in which a fraud claim will or will not fly. So most M&A disputes, the starting point and the end point is the SPA itself in terms of claims. So it's the warranties, it's indemnities, it's looking at the disclosure letter, the notice provisions, the financial caps and the time limits. And very often the claims in this field are just breach of contract claims rather than ones which look to go beyond the walls of the SPA. But there are situations where you may want to bring a fraud claim in addition to the breach of contract claim. And I'd suggest that there are 4, possibly 4.5 situations where you might want to bring a fraud claim. I think one of the primary reasons people look at fraud claims in SPA disputes is because you've got a situation where the buyer has overpaid. And the reason that can become important is because you can have a case where even if all the warranties given are true, the buyer has seriously overpaid for the shares. And that can create a real problem when it comes to a breach of warranty claim, because the focus on a breach of warranty claim is how much is the company worth if the warranties are all true, and then how much is it worth given that warranties are false. And it's that difference that you can recover in a breach of warranty claim. Now, the problem if you've overpaid is the warranty true value, the cap, the starting position is much lower than the amount you've paid. So you could have a situation where if the buyer has paid much more than they should have done, that ultimately they may have bought a company that's worth nothing if the warranty, given that the warranties are false, but they're still stuck with the cap based on the actual value of the company if the warranties were true. They can't actually recover the full amount that they've paid. And that can be really significant in terms of the difference it can make. Because in a deceit claim, you don't have that difficulty. In a deceit claim, the starting point is what you paid. And if you can show that what you paid as a result of the deceit is that there has been a deceit and that you paid a significant amount, and that had you not been subject to the deceit, then you wouldn't have bought the company. Then you're in the field of being able to recover the whole amount that's been paid. Even if you would have bought the company at a lower value, or the shares still do have value, you're still looking at potentially a much greater recovery, because you're looking at the difference between the amount you paid and what and the deal that would have been done, the value of the shares, had the deceit not been there. So potentially much more significant recovery. What other reasons are there? Well, there's the second reason and the third reason are related. They're to do with the sufficiency of the warranty claims. So there may be warranties, but they may not be the ones that matter. A risk may have been missed or not properly negotiated, and it may be therefore that the warranties aren't going to get you the relief that you need. Allied to that is the third reason. It may be that there's a warranty claim, that there's a good warranty claim, but unfortunately, due to the way that the SPA is drafted and the way that things have transpired, you can't bring it because you haven't given notice properly, you haven't given notice in time, you are otherwise subject to caps or limitation provisions in the SPA, which means that this brilliant warranty claim can't be brought. And you'd have seen cases before, may have been involved in cases where a warranty notice is served at what the buyer thinks is the very last minute, and it turns out it's the very last minute of the day after the day that the warranty notice had to be served. Or I've had cases where motorbike couriers have delivered to all but one of the warrantors, and the claim was only valid if all were served on time, and they were too late for one, or the person was on holiday and they didn't leave it there, and so on and so forth. So where a warranty claim has gone wrong procedurally, that can be another good reason. As can tying in non-warrantors, because of course you may have a situation where you've only got some of the sellers who are warrantors, or indeed people who are leading lights in the company who have made all sorts of representations, but who ultimately are either not warrantors or only given limited warranties. And this having additional defendants to go after, the additional disclosure, the additional pockets from which to extract cash, can be a very powerful reason for bringing a fraud claim. The half reason then, well, this is the idea that fraud changes the tone of litigation. And I know you hear quite often people say, oh, well, if they're accused of fraud, they will, they'll give up, they'd hate the professional reputation impact it may have if they're accused of fraud. And my own experience is that's not really what tends to happen. I tend to find my clients fall into the category of either knowing that they're fraudsters and not particularly caring, or strongly believing, rightly or wrongly, that they're not fraudsters and don't really see this as an issue. I think my own experience, at least, has been that most people don't view the label as being significant in its own right. Obviously, it can be different if people are regulated professionals, for example, but even then, I haven't tended to find that can be such a big reason. At the same time, though, the tone change is important because it does make an impact when it comes to looking for disclosure at the CMC, for example. It's easier to push it a bit further if you've got a fraud claim, and costs. But cost cuts both ways. If you make a fraud allegation and it fails, you're probably going to have to bear the cost on an indemnity basis. Likewise, if you make a fraud allegation and it succeeds, you're probably going to get cost back on the indemnity basis. And that, of course, can be pretty useful if what you're looking at is a complex and high-value fraud where costs are going to be very significant. So those are the reasons why you might want to bring a fraud claim. Just turning then to talk about a couple of recent cases. One which I think is really very much a buyer-friendly case, the other a seller-friendly case. And they're useful cases to have in your armoury if you're fighting fraud claims in this area. The first case is a Privy Council case, Credit Suisse and Ivanishvili. It's not actually a share sale dispute. It's a case from last year. It's an investment dispute, but it really matters in share sale disputes because the issues that arose are ones that very typically arise in fraud claims in this area. Now, what the Privy Council had to look at in this case is whether a claimant, so typically it's going to be the buyer, has to show conscious awareness of a representation in order to bring a fraud claim. Do they have to show that they were actively aware that a representation had been made? And it may seem like the answer to that is obvious. And one's instinct is probably that, yes, you do have to show that you're aware of the representation if you're going to bring the fraud claim. Otherwise, for example, how could you rely on it? The Privy Council, however, said no. The Privy Council said that actually people often act on assumptions generated by another's conduct. So someone acts in a particular way and that leads to you having an assumption. without separately articulating the representation to themselves, so they don't think out loud, oh, this is what's been said to me. Reliance remains essential, the Privy Council said, but reliance doesn't require you to consciously formulate the representation in your own mind. And you can see from a couple of examples how this works. So Ivanishvili itself involved a massive fund investment fraud. So there'd been discussions about fund investments between a client and a private banker at Credit Suisse. And it was held that these discussions gave rise to an implied representation that the particular fund in which he was going to invest was not being managed dishonestly. That had never actually been said. And it may well be that the client, an exceptionally wealthy man who didn't really give evidence dealing with this aspect, it may well be that he never actually consciously thought in his mind, oh, these funds are not being managed dishonestly. Probably never did. But the Privy Council said that doesn't matter. The way in which the fund was being discussed inevitably gave rise to implied representations. It gave rise to an assumption in the mind of the private client that the banker was not managing these funds dishonestly. And he relied on that assumption. He never would have invested otherwise. And that the Privy Council held was sufficient. Now, that's really useful in a share sale context. And the typical sort of scenario where I see that arise is where you've got meetings that have been conducted by reference to the company's accounts, pre-sale meetings, pre-sale emails, telephone discussions that are all being conducted by reference to the company's accounts, reference to particular figures in them, and so on. And in that situation, it's very easy to see how there's an assumption on the part of the buyer in many cases that the accounts have been honestly prepared, that they provide a true and fair view if they're the statutory accounts of the company's financial position. It may well be that the buyer isn't sitting there thinking, oh, it's been said to me that these are honest accounts, because it's not really the sort of thing that you articulate that way. But that doesn't matter. If that's an assumption that's generated by the way in which the accounts are being discussed, as often it will be, then as long as you're relying upon that assumption as a buyer, that's going to be sufficient. And if the seller in fact knows that that's not true, and it knows that you're likely to rely upon that assumption, then and you do rely on it, then you've got your deceit claim, even if you haven't got the conscious articulation. So Ivanishvili is a very buyer-friendly case. It's potentially very helpful in this sort of situation where you are looking for implied representations, perhaps because the seller has been quite careful as to what they put down expressly. But it does show you do need more than mere assumption. You do also need to be able to show the reliance and the dishonesty, of course. That then brings me to the second case, which is Jinxin and Auletta, a decision from earlier this year, a commercial court decision, which is in many ways a seller-side corrective. So it's a very topical case because it concerned the sale of a sports media rights business, which had rights connected with the World Cup. And it was a massive sale. The price paid was 715 million. And very shortly after the sale, the group completely collapsed. So the shares are valueless. The buyer alleged deceit, alleged fraudulent conspiracy too, but the commercial court dismissed all the claims, despite the fact that the buyer had been able to point to various figures that were wrong in the information that it had been given, and despite some unattractive correspondence and messy commercial background. I think the central lesson from Jinxin is that implied representations, so where you're trying to show that the provision of figures, for example, carries with it a representation that the figures are accurate, are very, very contextual. So you can't just cherry pick out figures, stick them down in a letter of claim or pleading, and say that there's been fraud because the seller knew that those figures weren't accurate. The court wasn't prepared to just simply look at these figures that have been plucked from vendor due diligence material, question and answer responses, and treat them as if they were freestanding, actionable assurances about accuracy. Instead, what it said was, you've got to read the whole materials as part of the whole transaction process. You've got to look at the disclaimers. You've got to look at the evolving negotiation. And here it was clear that the figures that had been given about performance originally had been rather overtaken by figures given later. You've got to look at the contractual protections agreed and the no reliance and entire agreement provisions. Now, often in a fraud dispute, people put to one side the no reliance and entire agreement provisions. Often there's a carve out in respect of fraud claims. But the court said you can't just simply throw them out in that way. You've got to bear in mind that they're there. You've got to bear in mind what warranties are given and look at the whole transaction process. And when you do so, what you may see is that actually it's quite clear, looking at the picture as a whole, that there was never any intention that the parties be able to rely upon these cherry-picked figures. And whilst they might look powerful when you simply extract them into a pleading, when you look at the whole chronology, when you ask, what's this document for? Is it tentative that contains the figures? Is it subject to assumptions? Is there non-reliance language? Had the parties moved on from earlier statements? And had they sought to deal with the matter contractually? Had they agreed a price negotiation clause that showed they weren't really relying upon the accuracy of the figures, and so on? But ultimately, standing back, you've got to look at the whole material transaction to see to what extent these figures really were intended to be figures that were put forward with assurances as to their accuracy, that they could be relied upon. Where do I think it leaves us after these two cases? Well, if you're for a buyer, Ivanishvili is very useful. Where you've got the seller's conduct creating an assumption, your client's acted on that, then that's a fantastic start. Where that assumption is false, where there's evidence to show it's dishonesty and relied upon, great, you're home with a deceit claim. But Jinxin makes clear that you have to be disciplined when alleging fraud. You've got to identify the representation, the conduct from which it arises. You've got to show that the assumption affects the client's decision-making process. And you've got to be prepared, Jinxin shows, to confront the SPA, the disclosure process, and the transaction chronology in detail. You can't simply rely on the client to give you a few figures that it's turned out were known to be false at the time they were provided. How about sellers? Well, Jinxin gives us a clear response. It says, you can't just say there's a no reliance clause, but you can put it forward, and you have to start with context. Show what the materials were for that were being provided, show the disclaimers, show the updates, show the contractual machinery which allocated the risk. And if the buyer is now saying, oh, well, this is a fundamental matter, question, why did it not become an express warranty, indemnity, or price mechanism adjustment? What was actually going on in the negotiations that this suddenly crucial matter doesn't seem to have featured in those ways? Or if it does feature in those ways, were the parties really intending that it give rise to a representation? So I think overall, the message from me is this. Fraud claims in share sale disputes aren't exotic. They're sometimes justified, but they're not a magic key to unlock a bad warranty claim. Ivanishvili is a very useful door opener for some fraud claims. But what Jinxin reminds us is that the court will look at the whole transaction, not just the most damaging passages within the transaction file. And it's important when we're coming to a case as well that we have very much an eye on the context in which any alleged representations have been made. So that's me and fraud. Next of all, we've got Lydia, who is going to talk about expert determination. Thank you.
Well, thank you, David, and good morning, everybody. I am going to talk about expert determination, and in particular, I'm going to be looking at two cases which consider how we can challenge expert determination. But before I do that, let's just put this topic in a little bit of context for those who haven't yet had the chance to have a second cup of coffee and are wanting a quick reminder. David mentioned in the introduction that in many share sale agreements, there's an element of deferred consideration. There may be some element which is contingent on a future event or which is delayed in order to make sure that everything is as it seemed. And usually what we find is that that provision in relation to delayed consideration will have some kind of formula to calculate what will be due. And also, if there is that ambiguity in relation to it, there will be a provision to say, if the parties can't agree, we go to an expert determination. And that expert determination will be binding on us absent manifest error. And so what we're looking at when we're looking at challenging an expert determination is whether or not the decision reached demonstrates manifest error. And there are two cases which have been out this year which look at manifest error, and one is a successful challenge of manifest error, and one is one which reminds us of how the test operates, but ultimately was unsuccessful. So I'm going to start with that one. That was the Court of Appeal decision in WH Holding and London Stadium, and that came out in February of this year. Now, some of you will be aware that I have a bit of a sports interest in my practice as well, and so I have shoehorned in a case with a sporting element. Although, to be honest, it has reminded me that I'm grateful we're doing this session this morning rather than this afternoon, where I fear attendance numbers would be quite different. This is a case which relates to West Ham Holding, and it's the case, as I said, WH Holding and London Stadium. West Ham Holding have an agreement with London Stadium whereby it's essentially a 99-year lease. It's a concession agreement which allows them to use the stadium as their home ground. Now, one thing to remember in relation to London Stadium is that this was a stadium built for the London Olympics with public funds. So part of the agreement with West Ham is an anti-embarrassment clause, which is intended to ensure that London Stadium get a share in the spoils of any qualifying share disposition by a relevant shareholder. In other words, if there's an increase in value, the public should get the benefit of it, given that they paid for the building in the first place. Not the entire benefit, a share. Now, it will not surprise you to know that the formula which is used to calculate what that share should be is not straightforward. In fact, in a relatively lengthy judgment, roughly 2/3 of it is occupied with explaining the formula and how it worked. You'll be pleased to know that I am going to simplify things, and I am going to focus on 3 elements of this formula. First, if the shares that were sold were less than 100% of the total shares, the exercise required an extrapolation to assess the value of 100%. So let's say 20% of the shares are being sold, straightforward matter. We would go through an extrapolation exercise, effectively multiplying it by 5 to work out what would this transaction be worth if we were selling all of it, and then we plug that number into the formula to work out what percentage applies for the contribution. So that's the first point. There's an extrapolation exercise if we're selling less than 100%. Second point, there are different provisions for extrapolation if we have a share sale or if we have a share option agreement. There were other provisions in relation to other scenarios too, but we're focusing on these 2 for today. And the third point is that the percentage that is payable depends on the value of the transaction. That may be obvious, but it's critical. So 3 points. There's an extrapolation exercise. The extrapolation exercise is different depending on the mechanism of sale, and the percentage payable depends on the value of the transaction. Let's get to the transaction. In November 2021, there was a transaction whereby 27% of WH Holdings was sold to a new company, 1890 Holdings. This was achieved not through one simple mechanism where the formula could easily be applied, but through a transaction which involved a purchase of existing shares, a call option to purchase more shares within a 4-month period, and a subscription of new shares. Now, we can put aside the subscription of new shares because that didn't come into the formula at all and is therefore very straightforward. The purchase of existing shares, everybody agreed, was part of a qualifying transaction. When the extrapolation exercise was carried out, that led to a transaction value which was sufficiently high that it led to a premium being payable. So that was relatively straightforward in one way. The big debate was around the call option. Now, the call option in terms of value was significantly more than the purchase of shares. The call option related to just over 1,000 shares, and the sale of shares was just under 200. So the bulk of the transaction is really found in the call option. And a premium of 18 million was being paid for this option. Now, the crucial question, therefore, was should we look at that call option as part of the share sale as well as one transaction, or should we be treating these as 2 separate transactions? And you might think, well, an 18 million transaction, surely that's going to attract a premium, so what's the problem? But the way the formula worked was when we applied the options extrapolation exercise to this particular option, it fell below the relevant contractual threshold once the formula was run through, and therefore it would lead to no payment being due. But if it was included as part of the share sale transaction as one transaction, then there was an additional 3.6 million liability. So it's readily apparent why this was such an important issue to the parties. They couldn't agree. They went to an expert for determination. An eminent commercial KC was appointed as the expert to determine the dispute. And he concluded that the call option should be included, meaning West Ham had to pay the extra 3.6 million with interest. In doing so, he relied, and I'm abbreviating the facts slightly just so we can get to the core principles from the Court of Appeal, but he relied on the definition of transaction, and in particular the fact that it said that any transaction having the same or substantially similar effect would be captured. And therefore he concluded it's not a kind of shopping list that I have to fit this into one of the specific categories. I can consider other transactions which have the same or similar effect, and I have to apply the principles from that formula to that transaction. And so what he did is he ran the two different extrapolation exercises. He applied a kind of pro rata assessment to that, and then he combined the sums to work out the transaction value. A lot of logic to that. That's what he did. West Ham understandably didn't want to pay an additional 3.6 million, and so they challenged that in the High Court. When I say they challenged it, really London Stadium sought to enforce, and West Ham sought to defend it on the basis that there was manifest error. And again, another commercial KC, very eminent in the High Court, found for West Ham and said that there was manifest error. And this, the judge, which was Paul Mitchell KC, concluded that in between the two extrapolation provisions, so if it's a share sale, this is what we do to extrapolate. If it's a share option, this is what we do to extrapolate. Between those two clauses was the word or. And he concluded that the effect of what the judge had done was effectively to treat that or as an and. And that wasn't appropriate. That was a manifest error. And that if he read that manifest error through and applied simple mathematics, it was clear that that went to the heart of the determination. There was manifest error and the determination would not be binding. So off we go to the Court of Appeal. And here we get to the principles that I really wanted to highlight for people in terms of how we challenge an expert when we're looking at manifest error. So first of all, they restated the classic statement of manifest error, which is found in the Weber oil case. And that is, manifest error refers to oversights and blunders so obvious and obviously capable of affecting the determination as to admit of no difference of opinion. Well, I'm immediately amused by the fact that we've got two eminent KCs who've reached different conclusions on manifest error. That statement of the test was approved in the Supreme Court in Sarah and Hussein Asset Holdings and Black Outdoor Retail Limited, forgive me. And again, that was then applied in the Court of Appeal here. And the Court of Appeal specifically highlighted the following points when considering whether a manifest error had occurred. First, this defence is narrow. A manifest error should be obvious and easily demonstrable. Second, being demonstrable means without extensive investigation. I will come back to that point shortly in considering one point the Court of Appeal rejected. Third, a manifest error should not depend on the outcome of a full-blown trial. And this goes back to it being easily demonstrable. Fourth, it wasn't wrong, as was suggested on the appeal, for the judge to determine first whether there was an error and then whether it was manifest. In fact, the Court of Appeal suggested that's what the test invites, those two stages to be considered. And the final point, which I think goes to the heart of the Court of Appeal's reasoning, was that an arguable error will not suffice, however well-founded the allegation of error may ultimately prove to be. And I think what you can read in the decision is that the Court of Appeal really understood, and perhaps if it was left to them, would have taken the interpretation that had been taken below and that West Ham were arguing for. And so they found that they could see the force of the argument and went so far as say, if we were doing it, we might well have found for them. But they said, actually, when we're looking at manifest error, the fact that it's an arguable error is not going to be enough. It was arguable that there was one qualifying transaction, as the expert had determined, that was not obviously wrong. There were elements of the agreement that could be pointed to which would support that conclusion. And so because it was not obviously wrong, so as to admit to no difference of opinion, the rest of the analysis that followed from that conclusion, it was equally not obviously wrong, and therefore the conclusion did not meet the standard for manifest error. Now, I said I was going to come back to a point in relation to the limited investigation, and it was suggested in the Court of Appeal that we should be drawing an analogy with the approach to challenging an arbitration, an arbitral award, and saying that we shouldn't really be having sort of adversarial argument on these points. And the Court of Appeal rejected that and looked at the mechanism in which these arguments come to be heard. And the mechanism is that the party who's the beneficiary, if you like, of the expert's determination will want to enforce it. And then the other party will want to defend on the basis of manifest error. And that is inherently an adversarial process. And therefore, the Court of Appeal said we shouldn't be drawing analogies with an arbitral process. And in fact, it is appropriate for there to be oral argument, oral evidence when appropriate, and that we shouldn't be limiting the test in that way. And the other point that the Court of Appeal drew out, which is also important, is there is a crucial difference between an expert who answers the right question wrongly and an expert who answers the wrong question altogether. And someone who answers the wrong question altogether with a material departure from their instructions, you don't have to demonstrate manifest error there, because that determination is not binding. It was never their task in the first place. So with that reminder of the narrowness of the defence and the principles that will be applied, I will turn to the second of the two cases that I was going to look at, which is Nawaz Khan and Williams and UAP Limited. And this is from May this year. It's a High Court decision. A little bit of background just to understand the findings and consider the implications. UAP were purchasing a business from Mr. and Mrs. Nawaz Khan and Mr. Williams. Those were the shareholders. And in the agreement, there was a provision for completion consideration and deferred consideration. And the determination of the final purchase price would be subject to expert determination in the event of dispute. Well, there was a dispute, or we wouldn't be talking about it, and the matter was referred to expert determination. Now, the clauses which were the focus of the dispute related to two particular sums. They're labelled claims provision and deferred fee income, but really the labels don't matter for our purposes. The point is that both parties approached the negotiation on the basis that these sums, these headings, led to an asset or represented an asset which would increase the value of the business on sale. And so when they produced their formula, a formula that you'd expect to see, where assets of value are added in on one side to calculate the business value, and debts and liabilities are deducted, these two headings were put in the asset side of the formula. And they were to be added in order to calculate the value of the business. So when it goes to the expert sees the figures in the accounts for those sums and adds them into the value. And that leads to an increase in the share value, an increase in the value of the business. Now, the shareholders, therefore, claimed for that sum, and the purchaser defended the claim, actually on a number of bases. First, on the basis of manifest error in the expert determination, but also they then counterclaimed for misrep and breach warranty and rectification. And some of the points that David mentioned may come in relation to that, so I won't overlap. But just focusing on the expert determination point, the first argument they ran was to say the expert didn't have jurisdiction because the expert had interpreted the contract and shouldn't have been. And they said, no, court gave that very short shrift. It's part of an expert's job to determine points of construction. And so it can't be said that that's outside of their authority. And then the second point was really the consideration of manifest error. And in this regard, the court found that the clear logic of the formula was to add things of value on one side and remove things and liabilities from the other side. And the reality was that these two sums were not actually matters of value. On the P&L, they were negative. And therefore, it was wrong for those to have been added without any consideration for the fact that they were actually reducing the value of the business. And they'd effectively been added and ignoring the minus symbol, which is crucial in these situations. Therefore, they had inflated the value of the business for something which there was no underlying asset which the purchaser would get the benefit of. And therefore, they should be removed. There was, in this case, a separate issue about preparation of the accounts and the method that had been used to draw it up, and the fact that that had been done to improve the appearance of the business. And some of the points that David mentioned sort of overlap in that regard. But one of the reason I mention this extra argument is because the court concluded that the approach that had been taken by the sellers in relation to this was indicative of a lack of good faith. And I think that probably that conclusion about the personality had an influence on the way in which they looked at the other matters. And just to briefly explain the misrep inducement and other arguments, they all essentially run on the same analysis, which is that the purchasers believed there were assets which corresponded with these two heads, claims provision and deferred income. They believed that based on the representations from Mr. Nawaz Khan, who was the active negotiator, and that they had relied on that representation to their detriment by agreeing to pay for them. As a consequence, the court was satisfied that they were willing to, it was appropriate to rectify the contract and to reflect the fact that without a corresponding asset, no additional payment was due. Key takeaways from this case. It's important to look at the clear logic of the position and the outcome. And it was entirely illogical to end up with a position where the business value was increased for something which actually was a liability for the business. Second point, we have to step back and consider the whole picture. And one of the points, as I mentioned, that I think was influential was this suggestion that there was a lack of good faith, that there had been an attempt to present the business in one way. And that definitely influenced the conclusions that were reached. And if we're looking at challenging an expert determination and we're looking at the way things have been done, looking at the whole picture and looking at the arguments will be relevant. And finally, it's important to consider whether there are arguments to run alongside the challenge to the expert evidence. So in this case, of course, we had the misrep and other arguments, and those can actually give us additional strings to the bow, which can help us to introduce some of that evidence, which may be influential. So with that look at those two cases, I will hand over to Alexander to conclude this talks from today's session.
Thanks very much, Lydia. I'm going to be talking on a different aspect of experts. I'm going to give some tips on what to do and what not to do in getting expert evidence from accountants and valuers. And that's based on the rather dramatic facts of a case I was involved in, led by our head of chambers, Adam Solomon. The case is called Marples and the Secretary of State for Education, a judgment last year in the Chancery Division. And very briefly, the facts were that the claimants were shareholders in a company which offered apprenticeships in the public sector and had a very large, valuable tens of millions of pounds worth contract with the relevant government funding agency, then called the Skills Funding Agency, the SFA. The claimants later sought to sell their shares in the company to a private equity firm for some large amounts of money. That required notification under the contract to the SFA, and the SFA had the power to decide that if the share sale and the change of control of the business would prejudice the delivery of services under the contract. If so, they could terminate the contract. What the SFA actually did was it decided to write a letter purporting to refuse approval of the share sale entirely, not terminate the contract, but refuse permission to sell the shares. And it became common ground at trial they had no power to forbid a sale of shares by private individuals. The claimant sued the Secretary of State, who was responsible for the agency, for misfeasance in public office and for negligence, alleging a breach of duty of care. The case had expert evidence on value. So while it wasn't a share sale dispute directly, you had to have valuers decide what were the value of the shares at the time of the aborted sale in order to work out what the claimant's alleged loss was. And the parties both instructed well-known expert accountants who were used in multiple previous cases. But what emerged was a litany of some of the worst things that experts could do on both sides, which led to permission being revoked on the claimant's side for them to call expert evidence entirely because their expert had breached his duty of impartiality. And on the defendant's side, it led to a complete rejection of his expert evidence on the facts. So I'll just very briefly run through the expert duties, but I'm sure you all know them. Someone suddenly lost sound. Does everyone else have? I'll take that as, thank you, I'll take that as other people are okay. So I'll run through the expert duties very briefly. An expert, of course, has a duty of impartiality and independence, a duty to assist the court, which overrides any duty owed to their client and their instructing party, a duty to give objective assessment of the facts, not just advocacy to help the party instructing them. But every single one of those duties was breached in this case. So I'm going to describe what happened through a series of tips to help all of us, hopefully, on what to do and particularly what not to do with obtaining expert valuation evidence. So the first point is, and again, it sounds like a very obvious one, but the expert should not contact the lay client and discuss the case with him. And this is the first point which emerged on the claimant's side. The expert had called the main claimant to discuss the joint statement, and it later transpired also to discuss the main report from the expert. And the lead claimant was himself an accountant and had been involved in running the business and knew the facts very well. And that discussion was done deliberately excluding the claimant's solicitors because the expert thought it was inappropriate for solicitors to have any involvement in the report of the joint statement. But he missed the rather fundamental point that it was also inappropriate for him to discuss all this with the lay client. And this feeds closely into the second tip. Number two, be very cautious as a solicitor or as counsel. Be very cautious if the client himself suggests the expert to appoint and check for previous engagement between them or for conflicts of interest. So the claimant's expert had the claimant's contact details because he had previously given expert evidence in a case in which the claimants were involved, not as litigants, but as in an advisory capacity. So they'd already known each other. And the claimants had suggested that this expert be appointed to the solicitors. And if the client is suggesting an expert, particularly in a technical field like evaluation evidence, it's important for solicitors to check how they know each other and emphasize there shouldn't be any direct communications between them. And if the experts already worked on a case in which the claimants were litigants or were involved in some way, that's a potential conflict of interest, which must be disclosed in the report at the outset, not as happened later, a long way down the line, almost at trial. Third point, and that's the worst part of what the expert did. The expert should not become the mouthpiece for the instructing client. Here, the expert sent a draft of the joint statement to the lead claimant and asked for his comments on it. The client provided really substantial comments, and it wasn't just new factual information. It was a whole paragraphs of advocacy written in the name of the claimant's expert, basically what he wanted the expert to say. And this is the worst bit of it. The expert then sent on this revised track change version of the joint statement to the other side's expert, leaving in all the client's comments with his name on in track changes. The only redeeming feature, I suppose you could say, was that the expert wasn't trying to hide the claimant's involvement, or if he was trying to hide it, he was too technologically inept to do it properly. But that's a very, very small positive for what's a clear, blatant breach of the duty of impartiality. The expert said later that he reviewed all the claimant's comments and agreed with all of them, and it was adopting them as his opinion. But that's a more fundamental breach. But that's missing a more fundamental breach. That he shouldn't have allowed the lay client to put words in his mouth in the first place, whether he agreed with them or not. It's simply not appropriate for a client to suggest things the expert should say. And the fundamental point is that the expert report and joint statement should only reflect the expert's own views. And so an important practical point is you must, of course, check that an expert knows his or her duties. However long-standing they've been as an expert, how many times they've given expert evidence in court, you still need to make sure they actually understand the duties involved. Because here the claimant's expert had given evidence for many years, and yet he had a completely misguided view of what his duties were, because he thought he'd done nothing wrong. Now, this was all done without the involvement or knowledge of solicitors or counsel, I should emphasise. And they clearly, none of us would have permitted it on our side if we'd known this. The expert did this deliberately. He deliberately kept out the solicitors from this process, thinking that was inappropriate, but talking to the client was okay. But the same criticisms of the expert passing on opinions from the lay client would, on different facts, also apply to comments from the solicitors or from counsel, if they had been the ones to edit his report and joint statement entries. Now, lawyers can edit reports for sense and language, particularly in some expert areas, not so much accountancy, but some expert areas where the expert perhaps doesn't write as well. Lawyers can also ask new points for the expert to consider, and ask questions to raise further thought in the expert's mind. But what they can't do is redraft the substance of the case, of the report. They can't say it would be helpful if you just say this, as exactly as the lay client had done here. They can't suggest new opinions because that would compromise the expert's independence. Fourth tip, if the expert has breached his duty, he must explain it properly, fully and frankly to the court. And here, the claimant's expert, when forced to by the other side, made a witness statement explaining some of these points on how the joint statement was edited. But under cross-examination, further points emerged which hadn't been included in that witness statement, including that he'd called the claimant about his original expert report as well, not just the joint statement, and how they'd worked together in a previous case. And none of that had been disclosed in the witness statement, let alone in the original report. So if you're trying to make a clean breast of a previous breach, you must do exactly that. You mustn't drip feed information, because it's going to come out anyway and it'll only look worse. And the judge found that even at trial, he still didn't feel he'd been told the full story of what had happened. So he ended up finding that the breach of duty was so severe that he had to revoke permission to the claimants to rely on expert evidence entirely. So you think that after the claimant's expert evidence was declared inadmissible, the defendant's expert evidence would be accepted almost by default, but not so. The defendant's evidence, as I said, was rejected as being unsupported on the fact and fundamentally illogical. I'll give you a few more facts to explain how this worked in context. The private equity firm who were going to buy the claimant's shares had originally offered £100 million for the shares. They then conducted due diligence and reduced that offer to 67 million. They then walked away for a period of time due to some changes in the market, and then returned with a revised reduced offer of around 55 million. So with that evidence, you'd think the company would be worth probably 50 to 60 million of what the later offers made by the private equity firm. But the defendant's expert said the company was worth only 2 million. So this is the next tip, number 5. The expert's opinion should be supportable on objective facts. Again, that should sound obvious, but in a valuation case where a sophisticated buyer has undertaken extensive due diligence and produced a figure that is willing to offer to pay for the company, that's very powerful market evidence of what the right ballpark figure is for the value of that company. And that's a proposition supported by a number of authorities and by the international valuation standards. And in fact, the defender's expert himself accepted that in principle. But the expert then tried to argue that the private equity fund had become a special purchaser. I wasn't offering market value because it had become so invested in, emotionally invested in this transaction that it was no longer offering market value. It wanted to buy the company come what may. And that's quite a striking thing to say for a private equity firm. The expert ended up saying that they had psychological factors. They just couldn't walk away, and they were so desperate to buy this company, they weren't acting commercially. That was contradicted by two inconvenient facts. Firstly, it's absurd, as I suggested, it's absurd for a private equity firm that they become emotionally invested in any company. They're going to act commercially and not pay over the odds. But secondly, on the facts of the case, the PE firm had actually already walked away and then returned with a new offer. So it's perfectly capable for them to walk away, and they clearly were comfortable with the revised offer they'd made. So this made the defendant's expert evidence pretty unsupportable on the facts. And the judge in the end found that the value was in the ballpark of what the private equity firm offered. And the sixth point is the expert should check his reasoning and logic, and the lawyer should as well. And again, that sounds very obvious, but it turned out that there was a fundamental and very basic logical/mathematical error in the defendant's expert evidence. The defendant's expert tried to find a way to bridge the gap between his £50 million offers by the PE firm and the defendant's expert's own valuation of £2 million. And he did so by saying that the PE firm would take advantage of a power under the SPA to restate the company accounts after the purchase and then claw back some of the purchase price. And he took various restatement claims or potential restatement claims and put in a heavy dose of assumptions, all against the claimant, a large amount of speculation of points he just didn't know, and then treated them all as reducing the consideration very heavily. He ended up accepting cross-examination that each one of these was hypothetical and none were actually properly made out on the facts. But then the final point was this basic mathematical logical error that he made and was never picked up anywhere in the report. The claimants were 2/3 of the shareholders in the company, and at the last third, who were also selling but didn't bring a claim, were other individuals. So they weren't claimants in the case. But the expert mistakenly took the total value of all these accounts restatement claims and deducted them against the 2/3 value that he given to the claimant's shares, saying that, oh, if we deduct these figures, it works out at about 2 million, so my valuation is right. He then had to accept in cross-examination that he'd made that basic error of deducting the whole reduced value of the company against the claimant's 2/3 of their shares. And when done properly, taking it against the company's value, the whole company's value, this led to the claimants receiving some 17 million, not 2. So at that point, the judge simply rejected his evidence outright as being unsupportable and unreasoned. So this tip really amounts to, just because an expert accountant, who obviously will be very numerate and math literate, just because he gives some figures doesn't mean he's right. You have to check the logic and check the maths on the fact on his report just as much as any other point. And just to conclude, a final point really applies to both experts. Tip number 7. The expert should reveal previous judgments where they've been criticised and learn from them, and equally solicitors and counsel can research previous judgments and see if it's in deciding whether the expert is someone we want to nominate in the first place. Because it turned out at trial that the claimant had been criticised in previous cases for becoming an advocate for the client, just as he'd done in this case, and for not revealing conflicts of interest. And other judges had criticised him rather heavily. He then slightly implausibly suggested that he had been unaware of these judgments and never been sent them and never bothered to look them up afterwards. So even if he hadn't been sent them, he clearly didn't bother to find out what other judges had said about him or to learn from them. The defendant's expert had also been criticised for doing exactly the same things he did in this case, producing fanciful, unsupportable views that may help the client but simply don't work on the facts. And there'd been a large number of judgments criticising him for that. And shortly after this trial, there was one rather excoriating judgment, again heavily rejecting his evidence wholesale for the same reason. So in conclusion, the claimant's experts' breaches of duty and breaches of the duty of impartiality and independence were clearly the more serious, and it's a rather stark warning to other experts as to how badly things can go wrong, and there's consequences for a party's case if they do. But the flaws in the defendant's expert evidence were ones actually we come across rather more often, and ultimately led to his rejection of his opinion on the facts, so it has actually just as bad an outcome in the end of trial. And those are ones which we can all perhaps learn from every day as to how to improve expert evidence we get. And both illustrate the temptations the experts can fall into, wanting to make the best possible case they can to the client, to get another instruction, to please the solicitors, but it's quite possible they ignore one or many of their duties that they owe to the court. And thanks very much, everyone, for listening. And if you've got any questions now for any of us, do put them in the chat, and both Lydia, David, and I can answer them.
Thank you very much, Alexander. Thank you, Lydia, too. I think at the moment we haven't had any questions that have gone in during the talk, so I'll just see if any come up now. Brilliant. Well, we hope this has been... Oh, we've got a question. Will the case references be shared? Yes, Julie, thank you. So we will put, after the call, we will put on a LinkedIn post, a Littleton LinkedIn post, both the case names in full and also a link to those cases. So that will go up shortly. We hope the talks have been useful. Thank you very, very much indeed for coming along to join us today. And we hope we will see you at a future Littleton Chambers seminar. Thank you.
Thank you.
Thank you. Bye.
This podcast was brought to you by Littleton Chambers. For more information on our barristers and clerks, please visit littletonchambers.co.uk.